Hello and welcome to the Minimum Competence episode for Wednesday, June 3rd, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, 2 Live Crew loses a copyright clawback at the 11th Circuit, Trump's AI cyber test EO is final, and Senate seats a not qualified judge. Let's remember, there is no greater tyranny than that which is perpetrated under the shield of the law and in the name of justice. And read today's legal news. On this day in legal history, June 3rd, 1916, President Woodrow Wilson signed the National Defense Act, the law that quietly built the legal scaffolding for how the United States deploys soldiers, both abroad and at home, for the next century plus. The act roughly tripled the size of the regular army, formally created the National Guard as a federalized reserve force out of the patchwork of state militias that had existed since the founding, and established the Reserve Officers Training Corps at colleges and universities. The legal hook is the dual status structure that the Act created and that we still use today. The National Guard belongs simultaneously to its state and to the federal government, normally taking orders from the governor, but can be federalized by the president under specific statutory authorities and pulled out of state command for federal missions. That structure has driven a long line of constitutional fights about the limits of presidential authority to call up the Guard, about whether and when the Insurrection Act applies, and about how the Posse Comitatus Act constrains the use of federal troops for domestic law enforcement. June 3rd is not a day most people associate with American military law, but the 1916 statute is doing the quiet work behind every modern headline about troops at a border, troops in a city, or troops in a hurricane. The 11th Circuit on Tuesday handed down a ruling that strips hip-hop group 2 Live Crew of the copyrights it thought it had successfully clawed back to 5 of its albums, including As Nasty as They Wanna Be, because one member's bankruptcy from the 1990s swept his future termination rights into the bankruptcy estate. Federal copyright law has a wonderfully democratic provision in Section 203. An author who signed away a copyright can, 35 years later, send a termination notice and take it back, regardless of what the original contract said. The catch the 11th Circuit identified is Section 541 of the Bankruptcy Code, which scoops up almost everything you own into the bankruptcy estate when you file, including, the court said, the right to send that termination notice years later, even though the right cannot be sold or contracted away in any other context. The practical consequence for 2 Live Crew is that member Mark Ross, who performed as Brother Marquez, had unwittingly transferred his future termination interest to his bankruptcy trustee when he filed Chapter 7 years earlier. So when the group's heirs and surviving members later tried to take the copyrights back from Lil Joe Records in 2020, they were 1 vote short of the majority the statute requires. The case, Lil Joe Records v. Christopher One Jr. et al., is described in the opinion as, quote, a question of first impression at the intersection of copyright and bankruptcy, which is lawyer speak for we just made up the rule and now it's the rule. Expect every copyright termination case where any author has ever filed for bankruptcy to cite this decision for the next decade plus. President Trump on Tuesday quietly signed a finalized version of the AI cybersecurity executive order that he had abruptly scrapped during a planned signing ceremony on May 21st, and the final version is notably narrower than the one that was on the table a month ago. The new order asks Treasury, the Department of Homeland Security, Cybersecurity and Infrastructure Security Agency, and other agencies to design a voluntary framework under which developers of so-called frontier AI models, the largest and most general purpose systems, would share their models with the federal government for up to 30 days before public release so the government can scan for security vulnerabilities. The legal posture is worth pausing on. This is a voluntary framework, not a regulation, which means it lives in the same constitutional space as a Chamber of Commerce best practices document, rather than a binding rule subject to Administrative Procedure Act notice and comment. That structure is partly a workaround for the fact that there is no federal statute giving any agency authority to mandate pre-release safety testing of AI models, and partly a response to industry pressure. Trump explained on May 21st that he scrapped the earlier 90-day version because he thought it could be, quote, a blocker to U.S. leadership in AI. Whether developers actually opt in is the open question, and the order is structured so that participation will likely depend on a mix of national security pressure, federal procurement leverage, and quiet diplomacy with major labs. Expect the first real fight to be over what counts as a frontier model and who decides. The U.S. Senate on Tuesday confirmed Katie Lane to be a federal district judge in Montana, making her the first judicial nominee of Trump's second term to be confirmed, despite a not qualified rating from the American Bar Association's Standing Committee on the Federal Judiciary. The ABA's role here is informal but historically important. Since 1953, the Standing Committee has rated federal judicial nominees as well qualified, qualified, or not qualified based on professional competence, integrity, and judicial temperament, and the rating has carried real weight for senators of both parties. Until it didn't. The Trump administration formally cut ties with the ABA review process during the first term on the theory that the ABA's ratings reflected an ideological bias against conservative nominees, and the second administration has been even more open about ignoring not qualified ratings as a matter of policy. The legal stakes of this are modest in any individual case. A not qualified judge serves the same lifetime appointment with the same constitutional power as a well qualified one, but cumulatively, the practice changes the relationship between the bar and the bench in a way that is hard to undo, and it nudges the federal judiciary in a direction that depends almost entirely on the political branch's definitions of professional fitness. Lane, who is now confirmed, will join the District of Montana, a small but busy bench. I would watch this space. There are several more nominees in the pipeline with similar bad ratings. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the history of liberty has largely been the history of the observance of procedural safeguards.